With the individual with the moniker owner, ma'am, please identify yourself. That's you, ma'am, and that she in the dark.
Hildemar Hathaway.
Oh, yeah, thank you, Ms. Hathaway. Would the other person on the owner and iPhone both? You're on two platforms there. Could you identify yourself?
Yes, Diane Clark.
Are you Damone? Are you related to Damone Clark?
Correct. Yes, I'm his mother.
All right. So ma'am, you should watch on YouTube. That we have a channel on YouTube that you can watch on. I'm not certain when that case will be called. It's scheduled for 9 o'clock, but we've got some cases, at least 8 cases in front of it.
All right. So is it okay to sign back in a little bit later, to leave now and then sign back in?
I think the easiest thing to do is to go on YouTube and watch it. Everything's live streamed on YouTube, so you don't have any problem there.
I will try that. I'm not certain that I'm able to do that. I'm just not that savvy with it. I actually had an invitation to the meeting, so.
Yeah, you don't need an indication. You just have to go to my channel, Tony Flores Courtroom channel, and then just click on it and it'll live stream, and then you can see the case when it comes up.
Thank you so much.
That might save you some time. All right.
Take care. Thank you.
So we're just so say it till they come up. Just say it till they come to the screen. Yeah, see everybody.
Mr. Fantera, you're here on Corrigan Towing?
Yes, I am, Your Honor.
All right, let's go ahead and call that case. So we're on the record in docket 22-01772GC. That is Corrigan Towing versus Hildemar Hathaway. Will the parties please introduce themselves for the record?
Good morning, Your Honor. David Fantera on behalf of Corrigan Towing.
Good morning. I'm sorry.
You are Hildemar Hathaway?
I am Hildemar Hathaway.
All right. This is the time set for a pretrial in the matter. Mr. Fantera, how did you want to proceed?
Well, I guess what I'd like to do is just get a trial date, and maybe I can speak to Ms. Hathaway and see if we can come to a resolution on that. And if not, you know, just get a trial date.
All right. we also have a pretrial statement that needs to filled out by both parties that would precede the pretrial date. I'll do a quick rundown of it so we have it. But I'll start with you, Mr. Fantera, and then I'll do that. Then I'll put you in a breakout room and get you a trial date. I just want to make sure we have the pretrial.
First of all, let me apologize. I normally would do that, except for I just substituted in on this case a week ago, and I was under the assumption that that was already done. So please accept my apology.
Right. No problem. And we that's often the case here. So I'm going to go ahead and put down Hathaway. I'm sorry, Corrigan versus Hathaway. Pretrial conference was held on today, February 21st, 24th. Appearing were David Fantera. And you said you're new to the case.
Yep. I mean, I'm aware of the facts, but I'm actually just
Right.
substituted in within the last week.
All right. From either party, are there any issues concerning this case that you want to bring to the court's attention for the pretrial statement?
Not on my end, no.
Other than the suit that's already been placed?
No.
All right. The pleadings are the complaint this far. Are there any additional pleadings that either side? I have the complaint and that's it.
That's all there is.
All right.
I assume there was an
Do you
answer
expect-
filed, Your Honor?
What's that?
Was there an answer filed?
There was an answered filed. It was certified. It was never picked up and it returned to me. And then we called multiple times to this Caitlin Harder, the original attorney. So we've been going back and forth and she's never responded back to me.
All right.
Was an answer filed with the court? I'm not so concerned.
Yes, there was. And it was
That's fine.
filed, the date on here was 8/17/22.
Let me see
54th
what I have
District
in the
Court.
file. And I'll see exactly what I have in the file. I have no idea what that is. Mr. Carter, you might want to put yourself on mute. The courtroom can hear you. I have a substitution of counsel. I have an order to dismiss. I have a boilerplate answer that was filed on August 17th,
That's what I sent, yes.
and affirmative defenses, and then the initial summons.
Then I think we're all
Do
set.
you anticipate any other motions in this case?
Not on my end, Your Honor.
Ms. Hathaway?
I don't think so.
Okay. And this isn't binding. I just want to have something for our civil division. We'll set this for discovery. How long do you think you need for discovery, Mr. Fantera?
60 days would be fine.
Does that suffice, Ms. Hathaway?
Sure.
All right, so we'll go to March, April. We'll do May 1st, 2023. Do you anticipate an expert witness, Mr. Fantera?
No.
Ms. Hathaway?
No.
Other than the damages sought for the summons and complaint or the lawsuit, do you expect to request any more damages, Mr. Fantera?
No, Your Honor.
Do either of you have a indication of whether you would want a jury or bench trial at this time?
Bench trial's fine.
Miss Hathaway?
That's fine.
All right. Do you estimate how much time, if there was a bench trial, would you think we'd estimate this for?
Just a couple of hours.
Would that suffice, Miss Hathaway?
Sure.
All right, and I will of course set it after discovery. Parties are to meet in breakout room. I'll indicate as a part of negotiations. I'm not going to set this for mediation at this point. So I will sign that document to that effect and have the document sent out to you. And then we'll set this for a date certain, and then I'll put you in a breakout room together. So civil will set, so you'll get a breakout, after the breakout room, our civil department will set a bench trial date after May 1st, which will be your time for discovery.
And we'll get that in the mail, Your Honor?
Yeah, you'll get that in the mail from our civil department. They do the civil scheduling.
And will that be in person or will that be by Zoom?
That'll be in person unless I hear differently from the parties.
Yeah, I think this is probably something that can be done by Zoom, but I'll leave that up to Ms. Hathaway.
All right, I'll wait to hear. We've got a little bit of time to work with. So civil will set jury trial.
Non-jury.
Pre-trial civil statement is done
Non-jury, Your
and
Honor?
signed. Go ahead.
I think you just said jury.
I'm sorry, bench trial. That's correct. The bench trial is will be set by the civil department after May 1st. And then I'll have them send out the pretrial statement so that both of you have a copy. And we put that all on the record. Mr. Fanter, Ms. Hathaway, would you like to meet in a breakout room as a part of this pretrial?
Sure.
Sure.
All right, I'm gonna have, so is there anything else other than the pretrial statement which has been filled out? And then you'll get a date time after May 1st. Is there anything else on 2201-772 before I put you in a breakout room, Mr. Fantera?
No, so when we finish speaking, we can just leave.
Correct.
All right, that'd be great. Thank you, Your Honor.
Right, Ms. Hathaway, anything else?
No, thank you.
All right, I'm gonna have Ms. Hathaway and Mr. Fantera placed in a breakout room. And you should hit a prompt and it'll take you right to the room.
All right, thank you.
Thank you. All right, Ms. Navjot, you're here for Citibank.
Good morning, Your Honor. Yes, I am.
All right. And I don't see anybody in the waiting room. I don't see a Christina Totten.
Yeah, I'm right here.
All right, Ms. Totten, come on up here. Go ahead and have a seat right here. You can have a seat right here. All right, this is the time set for a pretrial in the matter in docket 2202-743 GC Citibank versus Christina Totten. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Navjot Francis on behalf of Plaintiff's Attorney of Record B72322.
All right, and ma'am, you are Christina Totten?
Yes.
All right, thank you. This is the time set for a pretrial in a civil matter. Ms. Navjot, Ms. Totten is here physically in person. You're on Zoom. How would you like to proceed?
Your Honor, we have agreed to a consent judgment. Defendant has also made her first payment. However, we have not received the consent judgment back yet. So
Miss-
if I could get an update from her, if she did send it in.
All right, so all they're looking for today is some update on the consent judgment.
Yes, there was a consent judgment. I'm working with Beyond Finance, and there was a judgment put through them. It was like 1,800 something. I did send them, that I was good with that. I sent them that a couple of weeks ago. I'm not sure why they never passed it on to city.
All right, so she's working with an agency,
Yeah,
and there's an indication that consent judgment was confirmed and then sent on to you, but you don't have it yet,
No, Your Honor, we don't.
right? So we're
If we
somewhat in
could,
a little bit of a waiting game for that consent judgment. When was that signed, ma'am, for the record?
I don't know. I have it on my phone. I can look. Not sure. It was like January.
You'd say January this
The
year?
end of January, yeah. Beginning of February. It was not that long ago. A couple weeks ago, maybe.
So Ms. Totten indicates it was the end of January, beginning of February of this year was when it was signed.
Your Honor, if I may then, maybe we can submit it under the 7-day rule, since I'm guessing it's the mail issue, and instead of waiting for it again, I could place the terms on the record.
Yeah, if you want to place the terms on the record, and then we can indicate that we'll wait for paperwork from you, and then if you need it set again, let us know. I'm not going to dismiss the file until I see that there's a resolution on the file. But what are the terms of the condition of the is it a consent judgment or a conditional dismissal?
It's a consent judgment.
Okay, what are the terms of that?
So the consent judgment is for the full balance. The damages are $2,662.79, costs of $120.37 for a total of $2,783.16. We do have additional terms that defendant may satisfy this judgment by paying a total of $1,865, by paying $75 starting February 10th, 2023, and then making payments of $428.75 starting April 10th, 2023, until the settlement amount is paid. If she does default, then we would proceed with collection on the full balance of the judgment.
All right, Ms. Totten, is that your understanding of the agreement?
Yeah, and then I was notified by Beyond Finance that I had to sign and date it and send it back to them, and I did, and I never heard anything.
So we're just in the middle of waiting for it now. What Ms. Navjot has proposed is that she would submit to the court once she receives that a dismissal under the 7-day order, and then that would end the case from their perspective. If not, then maybe we'll set it back on for hearing and see the status of the case, because we're kind of waiting for your paperwork to get to them. Does that make sense?
Can I send it directly to her?
Ms. Navjot, would you, the plaintiff asked, I'm sorry, Ms. Totten asked if she could send it directly to you just as a backup. I think that's a great idea.
That would be fine.
All right, do you have the address to send it to?
No. Is there an email, or is it
I can give my email.
All right, let's do an email address and we'll write it down for you, ma'am, okay?
Okay, that's fine.
So what's the email, Ms. Navjot?
It's NAV
NAV
at silversteinlegal.com.
at Silverstein Legal, SILVERSTEIN
Yes, legal.com.
legal.com. All right.
Yes.
All right, we'll provide that email address to Ms. Totten so that she can, it's just as a backup plan to send it also. And my court officer will provide that to you. And then we'll await for the paperwork to get to where it needs to be. And then you indicated you would send in a consent judgment to that effect. Is that right, Ms. Navjot?
Yes. If we receive hers, we'll send that in. If not, we will just submit one under the 7-day rule.
All
if
right,
That's okay with the
okay.
clerk. Or Ms. Totten, if you give me permission, we can just sign your name to the one I have and submit it.
Okay.
All right, perfect.
Okay, so we'll do it
Anything,
that
do
way.
you have that email address, ma'am?
Do I have
All right, our office, my court officer will give that to you. All right. Anything else for the
Well,
record docket 22-02743? Ms. Navjot.
Ms. Totten doesn't need to email it to me. We'll just sign her name since she gave us permission, Your Honor.
All right, all right.
Thank
Okay.
you.
So I don't need to email it then, okay.
All right,
Yep.
perfect. Then we'll give you the email address anyway, but you don't need it.
Okay, okay.
All right, anything else, Ms. Totten?
Nope, that's it.
All right. All right, that's all for the record docket 22-02743. Ms. Navjot, have I said your name correctly?
Yes,
It's
Your
Miss
Honor, that
Francis,
is my
right?
first. It is.
Yeah, it's Miss
I think-
Francis.
I
Okay.
think we do
I
that every
apologize
time.
for that.
It's okay.
All right, thank you for your appearance today. Thank you, Ms.
Thank you.
Totten.
Thank you.
Okay,
Mr. Smith is already on Shelby Eddington.
okay. All right, we're on the record in docket 1602-033. Mr. Smith, we'll place appearances for the record on the file.
You bet. For plaintiff Laptu Tim Smith, P48259. Good morning, Your Honor.
Good morning. And ma'am, you are Shelby Eddington?
Correct.
All right. This is the time set for, there was a show cause on this, and it appears that both parties have met in regards to the breakout room. In regards to, my understanding was, Mr. Smith, you needed some information concerning a collectors or a debtors conference. Mr. Smith, how are we proceeding today?
We've completed the Q&A part of that creditor examination, Your Honor. I did get the information needed from Ms. Eddington. She was very helpful in that regard. There are some documents, though, that are responsive to the court subpoena, namely some banking records. She thought that 14 days was enough time to get me copies of those. I'm going to, and more importantly, we did agree to a payment plan that fits her ability to pay. I believe she's comfortable with. I'm going to send her a letter confirming the parameters of that payment plan, reminding her where to send the documents that the court order produced. I think for purposes of today, we're done, other than I believe she posted a $250 bond, cash bond, and we would ask that that be released to my office. And Shelby, just so that you know, when those monies are received, 100% of that will be applied against the balance owed on the judgment. Okay.
Okay.
All right. All right. So, Miss, this was an order set for, this was a previous, I believe, failed to comply with a May 19th date. But Mr. Smith, you're satisfied that you have everything you need today?
I am. We had a very good conversation, and she understands that if she doesn't forward the documents to me, that she and I will end up right back here again on a motion to show cause, and I have every reason to believe that she nor I want to be here again.
Right. I will take that as a compliment, Mr.
Nothing
Smith.
personal, Ron. Nothing personal.
Miss Eddington, so we're going to release the bond posted to the civil party, to Mr. Smith, to go towards the amount owed.
Okay.
And then I'll put that reminder letter in the mail to you, Shelby. When you get it, if you have questions, let me know. We'll lay out everything we discussed, and you've got my phone number. You can call me anytime.
Okay. Sounds good.
All right. And then Miss Eddington is in relation, I'll just dismiss the show cause that is
Please.
set, that was set against you. So I'll dismiss the show cause.
Yep.
Okay.
It appears that we're all set, as long as you keep in touch with Mr. Smith and make sure he has the paperwork. Okay.
All right. Sounds good.
All right. Anything else for the record, Mr. Smith, in 1602-033?
Nothing, Your Honor. Thank you.
All right. Miss Eddington, anything else?
Nope.
Okay. You're all set. Thank you for your appearance today.
Thank you.
See you.
The motion was the last one, right? I'll have to unmute. All right. So, sir, you are Marcel Carter?
No, sir.
Okay. Well, now we got two Marcel Carters. One in the corner and one who just said he's Marcel Carter.
He said he's not.
Oh, he's not. Oh,
Yes, no,
Mr.
sir.
what's your name, sir?
Shalari Clark.
All right. Mr. Carter, you'll have to unmute yourself. You're on mute, Mr. Carter.
Hello.
Okay, thank you. Sir, you are Marcel Carter?
Yes, sir.
All right. This is the time set for a probable cause conference. Ms. Rolfe, how are we proceeding?
Your Honor, it's my understanding that defense wishes to leave this on for preliminary examination. We have extended an offer to a misdemeanor DV with no objection to 7694A.
Okay, there's an outstanding offer of misdemeanor DV with 769-4A, you indicated?
Yes, Judge.
All right. But at this time, it's left on for March 3rd at 8:30. Is that correct, Mr. Coltrider?
That's correct, Your Honor.
All right. So we've had the probable cause conference. Mr. Carter, your preliminary examination is left on for March 3rd at 8:30. And there's an outstanding offer that Mr. Coltrider can discuss with you. All right.
Okay.
All right. Anything else for the record, Ms. Rolfe, in docket 23-00496?
No, Your Honor.
Anything, Mr. Coltrider?
No, Your Honor.
All right. Thank you. Mr. Carter, we'll see you next week.
Okay. Great.
You're all set.
Okay.
Who's next, Ms. Rolfe?
Your Honor, we're ready on Mr. Ishmael Johnson.
It's right there. All right, we're on the record in docket 22-01259. That is People of the State of Michigan versus Ishmael Johnson. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Kristen Rolfe on behalf of the people.
Erin Robinson, Assistant Public Defender for Mr. Johnson.
And sir, you are Ishmael Johnson.
Yes, Your Honor.
Okay. This is the time set for a probable cause conference. Ms. Rolfe, how are we proceeding?
Your Honor, it's my understanding we have extended an offer for the defendant to plead to count 1 CCW. We would dismiss count 2 and people would consent to HIDA. It's my understanding the defendant actually wishes to accept that offer, but I'll defer to the court whether or not we can do that plea today. I'm willing to do that plea today, but I understand there might be some paperwork and things that need to happen.
Yeah, I think in order for us to take a plea in district court, we have to get some paperwork together in order to provide it to circuit court, because that's the sentencing court. We're just the plea court, but there's a packet we have to put together for them. If that's the case, we leave it on for prelim and do it next week, if that's amenable.
That's fine, Your Honor.
All right, that should give us plenty of time to put together the packet. Okay, so we'll set it for plea next week at the same time. So set for plea in district court we'll just use the preliminary examination date, November 3rd. I'm sorry, I looked at the wrong one. March 3rd, 2023. At 9 a.m. And at that time, we'll start the process to circuit court, okay? Anything else for the record, Ms. Rolfe, in 22-01259?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor, thank you.
All right, we'll see you next week, okay? All right, thanks. That's all for the record on 22-01259.
And then, Your Honor, I think the parties are ready on Ashley Hernandez next.
All right. So this is yesterday's.
Civil,
I do have an order of fingerprints.
Yes.
Mr. Hernandez. So we're on the record in docket 23-00178. The people of the state of Michigan versus Ashley Hernandez. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Natalie Maycomber on behalf of the people.
And good morning, Your Honor. Jared Austin appearing on behalf of Ms. Hernandez. She appears with us today remotely via Zoom.
All right, ma'am, you are Ashley Hernandez?
Yes, sir.
All right, first things first, there's an order of fingerprints. Ms. Hernandez, you got to come in here and have your fingerprints taken, okay?
I did that, sir.
You did that already?
Yes,
'Cause
sir.
I have an order that you couldn't do it without.
I did that yesterday.
All right. So, all right, so the information in the computer is not caught up with the file, so if you've done that, perfect. All right, ma'am?
Okay, thank you.
All right, so this is time set for a probable cause conference. We also, for the record, we had a civil hearing on the matter that was scheduled for yesterday, but yesterday was a little bit of a mess in general, just because of the weather. So we've just put it with this file, all right? So as part of the PCC and the civil file, Ms. McComber, how are we proceeding?
Thank you, Your Honor. And again, I apologize to the court.
Don't worry about that.
Misunderstood yesterday's date. It's my understanding that we are leaving the case on for next week for both the preliminary examination and the forfeiture hearing. However, an offer has been extended to Ms. Hernandez that I believe Mr. Austin will be speaking to her about. So I'm hopeful that we can resolve this next week without having the hearings. That offer is that Ms. Hernandez would enter a guilty plea to an added count of animals abandoning or cruelty 2 to 3 animals, which is a 1-year misdemeanor. In response, the people would dismiss the balance of the information or the complaint against her. We would also require, as part of that plea, that she surrender the animals that were seized, and restitution would be determined at sentencing. There would also be a killable agreement to no further jail at the time of sentencing, so long as she agreed to terms of probation.
All right. And is that your understanding of the outstanding offer made by the people, Mr. Austin?
That is correct, Your Honor. I received that offer yesterday evening after I already spoke with Ms. Hernandez, so I've not had a chance to convey with that offer to her and speak with her about that yet. So for now, we would ask the preliminary hearing be left on. I will speak to Ms. Hernandez and see what her intentions are, and I will update Ms. Maycomber accordingly.
All right. So, Ms. Hernandez, is that your understanding? It's going to be left on for prelim on March 3rd at 9 a.m. There's an outstanding offer that you're going to discuss with your attorney, Mr. Austin. Is that your understanding, ma'am?
Yes, sir.
All right. I'm also the civil file that's a part of this, I'm going to leave on for next week also, so we can address any civil issues at that time, just for expediency purposes, if anything. All right, anything else for the record in docket 23-00178 or the accompanying civil file, Ms. McComber?
No, Your Honor, thank you.
Anything else, Mr. Austin?
Nothing further on behalf of Ms. Hernandez.
All right, Mr. Hernandez, we'll see you back here on March 3rd at 9 in order to continue this case. All right, ma'am?
Yes, sir.
All right, you're all set. Thank you for your appearance today.
All right, thank you.
Thank you, Judge.
Thank you, Mr. Austin. Thank you, Ms. McComber.
Thank you, Your Honor.
When you're ready, Ms. Rom.
Your Honor, we're ready on Joshua Reedy ×3.
All right, and we'll probably have to bring Mr. Reedy up, right? Oh, they put him on Polycom. So we're trying to figure out where he is.
He is in jail, Your Honor. Today's the PCC. We're fine with we're planning on leaving it on already, Your Honor.
Want to just leave it on?
That's what we'd like to do.
All right.
Yeah. Yeah, I don't believe that his appearance is going to be necessary for today's hearing.
As long as you're willing to convey that to him, I'm good, Mr. Mayor.
Absolutely.
We'll put it on the record that he's not. Let me grab those files so we can move on. We'll just indicate that he's not here on Polycom yet, and we're just leaving it on, so there aren't any decisions to be made. right, so we're on the record in docket 23-00492, 493, 497. That is people of the state of Michigan versus Joshua Reedy. Will the parties please introduce themselves for the record?
Kristen Rolfe on behalf of the people.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Reedy. Mr. Reedy is currently incarcerated, not with us today via Polycom. And I would note, Your Honor, that we don't see a need for him to actually be here today for the purposes of the PCC, largely due, well, most likely due to some of the issues that have been going on since the recent storm, Your Honor, is what I'd be guessing, I guess.
Right. Ms. Rolfe, is that an accurate statement?
It is, Your Honor.
Right. So my understanding is we're just leaving it on for preliminary examination, and then we'll address whatever issues in the case there. But at this point in time, with the 3 files, we're just leaving it on for the March 3rd date at 8:30. Is that correct?
Yes, it is, Your Honor.
All right. Ms. Rolfe, is that your understanding?
It is, Your Honor.
All right. So we'll leave it on for March 3rd at 8:30 for prelim. Mr. Reddy, we could wait for Mr. Reddy to see if we can get him on Polycom. Since we're just leaving it on, that doesn't seem to be an efficient use of time, or at least any use of time. So at this point in time, anything else for the record in docket 22-00-492, 493, or 497? Ms. Rolfe?
No, Your Honor.
Anything, Mr. Milks?
No, thanks.
All right, thank you. That's all for the record. We'll leave those on for prelim for next week.
Thank you.
And then, Your Honor, I think we're ready on Mr. Cameron Thornton. This was a add-on for the competency report.
All right. And I see Mr. Thornton is joining us by Zoom. All right, we're on the record in docket 22-01983, people of the state of Michigan versus Cameron Thornton. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Kristen Rolfe on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Thornton, who is joining us via Zoom.
And sir, you are Cameron Thornton?
Yes, I am.
All right. And you can hear me all right, Mr. Thornton?
Yes, I can, Your Honor.
This is the time set for this was scheduled a competency hearing concerning Mr. Thornton. Ms. Rolfe, how would you like to proceed?
Your Honor, the people are in receipt of a letter from the Forensic Center dated February 17th, 2023. In that letter addressing the court, Andrea Van Denberg, VanDenbergh, writes to the court and states that the above named defendant, Mr. Cameron Thornton, has been opined incompetent to stand trial and not likely to attain competence if provided a course of treatment within the time limit established by section 1034. So pursuant to this letter and opinion of the Forensic Center, Your Honor, people will not be proceeding on this case. We will file a nollie and very likely petition him. However, the APA, as I understand it, does that in our office. Lori Freed takes over that part, so I can't speak to when the petition occurs. So with that, I would say I'm not prepared necessarily to do the nollie at this moment. I would just want to hear back from her so we don't have a gap.
And you've spoken with Ms. Sutter about this?
She advised me that it would be a dismissal and possibly a seeking civil commitment.
All right, yeah, that's my understanding, as to the order that those are some choices we have, and you've taken care of my choice, to dismiss the case with the understanding that the people are gonna move to have the person petitioned as a person in need of PRT. I understand that that's a different person in the office. So in relation to the dismissal will come once if there's a certainty that petition's being filed, I would guess.
Yes, Your Honor, I've dealt with cases similar to this
Right.
before, and we will file our NALI. It does come usually really, really quickly, actually.
Right.
I don't know Ms. Freed's availability when she's
All right.
in our office that does that.
So I'm assuming there's no objection to me signing the finding an order of competency concerning box 3, which is what you indicated. And that we can tell him on the record, as he's heard, that there is planning to be a PRT filed in regards to a person requiring treatment under the civil code.
That's accurate, Your
All
Honor.
right, Ms. Sutter, is that your understanding?
It is Your
Okay.
Honor.
Mr. Thornton, you heard what everybody said here?
Yes, I have.
All right, so there is going to be a nollie pros filed in regard to dismiss. You can talk to Ms. Sutter for those reasons in regards to that. There's also out of the prosecutor's office, there's been an indication that they are going to move for you as a person in need of treatment or person requiring treatment under the mental health code. And you can talk to Ms. Sutter about some of those implications. Okay, Mr. Thornton?
All right, Your Honor.
All right. I'm gonna, for the record, I'll sign the order. Indicate that the competence hearing was held. Order was signed. And then we'll await the nollie pros, and then the civil proceeding can take its course. Anything else for the record in docket 2201-983, Ms. Rolfe?
No, Judge.
Anything else, Ms. Sutter?
No, Your Honor.
All right, Mr. Thornton, do you have any questions of me today?
No, I don't, Your Honor.
All right, thank you. You're all set, Mr. Thornton. Good luck to you, okay?
Okay, thank you.
You're welcome. Motorola, sir, on the Motorola Moto G stylus cell phone, is he connected? No. Sure. You're all set.
Cameron, you're okay to log off. You're set for today.
Okay.
Thanks.
She's connecting to audio as we speak. There we go.
Okay.
So you ready to proceed on Ms. Strunk's case? I also have an order of fingerprints on Ms. Strunk. So when I'll let her know. Okay. All right, we're on the record in docket 23-00363. That's People of the State of Michigan versus Emily Strunk. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Kristen Rolfe on behalf of the people.
Good morning. Edward Hess on behalf of Ms. Strunk. Ms. Strunk is appearing by video conferencing. I'm present in the courtroom on her behalf.
All right, ma'am, you are Emily Strunk?
Yes,
And you can hear me all right, Ms. Strunk?
yes, sir.
All right. For the record, Ms. Strunk, it's incumbent upon you, and I don't know if you've done this already. You got to get your fingerprints taken, all right?
Okay, I can do that today.
All right, thank you. That's perfect. We have an order in the file, and if you take care of it today, we'll be all set. In regards to the probable cause conference that's set for today, Ms. Rolfe, how are we proceeding?
Your Honor, it's my understanding that we are leaving this set for the preliminary examination. People have not extended an offer at this time.
Is that your understanding, Mr. Hess?
That is correct, Your Honor.
Yeah, we're leaving set for preliminary examination on this case for March 3rd at 9 a.m. So, Ms. Strunk, you've heard the attorney speak. We're leaving this on for preliminary examination for next week, March 3rd at 9 a.m. All right, ma'am?
Okay, sir.
All right, and if you take care of that order of fingerprints, that'll be all taken care of today. Is that correct?
Correct.
All right. Anything else for the record in docket 23-00363, Ms. Rolfe?
No, Judge.
Anything, Mr. Hess?
Nothing further.
All right, that's all for the record in that file.
And then, Your Honor, we're ready on Mr. George Smith. I understand that he's a capias and not, well, unless he's the Moto G.
Yeah, let's,
I guess I won't speak too soon.
yeah, I just don't know. I don't know who is, oh, he's got audio now. With the individual who just drank the cup of the styrofoam cup on the Motorola Moto G stylus, please identify yourself.
My name is Christopher Lavoie.
Christopher Lavoie. Okay, thank you, Mr. Lavoie. You're in the right place. We'll just call some cases, so stand by, okay?
Okay, thank you.
Judge, we can handle Mr. Lavoie's case if you'd like.
Okay.
Mrs. Robinson indicated that it would just be left on for exam.
Okay.
The week it ain't so bad. Just depends on what time you get here.
All right, so.
I didn't have a whole lot. Just one little.
All right, Mr. Lavoie, we'll call your case.
Okay, thank you.
Then tomorrow.
Okay, we're on the record in docket 23-00387. It's people of the state of Michigan versus Christopher Lavoie. Will the parties please introduce themselves for the record?
Kristen Roth on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. Lavoie in place of Ms. Robinson.
And sir, you are Christopher Lavoie?
Yes, sir.
And you can hear me all right, Mr. Lavoie?
Yes, I can.
All right, this is the time set for probable cause conference. Ms. Rolfe, how are we proceeding today?
Your Honor, Ms. Robinson indicated to me this morning that Mr. Lavoie wishes to leave the preliminary examination set. And at this time, no offers have been extended.
And is that your understanding, Ms. Sutter?
It is.
All right, so we'll leave it that's set on for March 3rd. Is that at 9 o'clock? Looks like 9 o'clock. 9 o'clock, okay. So, Mr. Lavoie, you've heard the lawyers speak in this case. Your preliminary examination is left on for March 3rd at 9 o'clock, okay, sir?
Okay, thank you.
All right. Anything else for the record in 23-00387, Ms. Rolfe?
No, Judge.
Ms. Sutter?
No, Your Honor.
All right, we'll see you next week at 9 o'clock on March 3rd, all right, Mr. Lavoie?
Okay, thank you.
Thank you.
Okay, and then unless there's another person that we don't know on Zoom, I think Mr. George Smith is a capias, Your Honor,
All right.
and not present, and so I think we can proceed on that one.
And Mr. Lavoie, you're free to leave the Zoom courtroom. Let's go, Mr. Smith. I thought she said Smith, but we can ask her.
Good weekend, Judge.
You too, Mr. Mills.
Don't forget your charger.
Was it his charger?
Yeah, some idiot left it last night.
We were just trying to figure out who it belonged to. And so,
It was this guy.
Okay.
yeah, we blame Mr. Etheridge.
Yeah,
I got two in Word.
Was it Core?
In Word, okay. I'm gonna put this up with Derek after this. So
We'll sort out.
We'll chat.
What's that?
I'll get my people finding your people. Someone else needs to sort of- Uh-huh. Because I get to watch it.
Clark?
Just like this application is-
Mr. Driscoll, are you here on Shallery Clark?
Yes, Your Honor.
All right, we have an appearance from the public defender. Have you filed a substitution of appearance?
I did send an email late last night, getting the substitution in. I was able to speak with the public defender to get that taken care of yesterday.
All right, so and Mr. Clark's here. We'll stand by on that. Did you have a case you want to put on the record?
If we could, Your
Okay.
Honor, Mr. George Smith is not with us.
All right, so we're on the record in docket 22-03191, people of the state of Michigan versus George Ernest Smith or Smythe. I'm uncertain how that's pronounced. Will the parties please introduce themselves for the record?
Kristen Rolfe on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Smith, standing in for Ms. Robinson this morning.
All right, this is the time set for a probable cause conference. It was set for 8:30. It is now 9:32. It appears the defendants failed to appear for the probable cause conference. Ms. Rolfe, how did you want to proceed today?
Your Honor, at this time, I would request the court issue a bench warrant and bond forfeiture in this case.
Okay, Ms. Sutter?
Your Honor, I would ask if at all possible 48-hour hold be put on the bench warrant. My understanding is this is not a violent case, so I would just ask for the 48-hour hold to be considered.
Possession of methamphetamine case. But I do have he failed to appear for an arraignment on December 1st. Do you have that, Ms. Rolfe?
I do not, Your Honor.
There's a failed to appear. They actually did a motion and bench warrant on it. So with a prior failed to appear in early December, looks like this was December, it was notarized December 6th, or it was by on December 6th. I'll issue a bench warrant and bond forfeiture with a prior fail to appear. It is a non-violent case. It's still a 10-year felony, but he did fail to appear previously. So bench warrant and bond forfeiture is issued.
Thank you, Your Honor.
Anything else, Ms. Sutter?
Nothing further. Thank you.
All right, thank you. That's all for the record in docket 22-03191.
Thank you, Your Honor.
Thank you. Then we're on the record. Are you ready to go on Mr. Clark then?
That is not my case.
Okay.
That is APA Adam Pfeiffer, Your Honor.
All right.
Let me just. Okay, thank you. This letter's gonna go check and see.
All right. He's probably collecting his awards because, he's one of the 5 under 5 this year. So.
Yes, very prestigious.
Yeah, it is. It is. So, Mr. Driscoll, once your assistant prosecutor gets here, we'll call your case. Okay.
Thank you, Your Honor.
All right. Thank you. myself off mute. All right, Mr. Driscoll, we're ready to call Mr. Clark's case. So we're on the record in docket 23-00353. That's people of the state of Michigan versus Keith Driscoll, Shallery Clark. Will the parties please introduce themselves for the record?
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Keith Driscoll on behalf of the defense, Mr. Shallery Clark.
All right, sir, you are Shallery Clark?
Yes, sir.
All right, and you can hear me all right, Mr. Clark?
Yes, sir. Can you hear me fine?
I can, thank you. So this is the time set for a probable cause conference. Mr. Pfeiffer, how are we proceeding today? I believe Mr. Driscoll just filed an appearance in the last 24 hours.
Yes, Your Honor.
So how are we proceeding today?
Well, Your Honor, the preliminary examination is scheduled for March 3rd, 2023. I would leave it up to Mr. Driscoll as to whether an adjournment is needed in order for him to have more time to look over the evidence, as I'm assuming he does not have yet, and review it with his client. Otherwise, people be prepared to proceed for examination on March 3rd.
All right, Mr. Clark, Mr. Driscoll, it's kind of in your corner. It's set for March 3rd, 2020, 8:30, unless you want some more time to review whatever documentation is necessary in order to advocate for your client.
I would be prepared on March 3rd, Your Honor, so we're set to proceed.
All right, so we'll leave on for preliminary examination for March 3rd at 8:30. So, Mr. Clark, please keep in contact with your attorney, Mr. Driscoll. This is left on for preliminary examination on March 3rd at 8:30. All right, sir?
Your Honor.
Go ahead, Mr. Driscoll.
May I ask for motion of the court for a bond modification, specifically to remove the GPS with victim notification from Mr. Clark's bond?
You can so we can ask for a modification in bond, but this is left on for prelim on March 3rd at 8:30. And then, Mr. Driscoll, I'll orally hear a modification of bond as a request.
Yes, Your Honor. So I'm sorry, Your Honor, you'd like me to proceed forward now on that modification,
Please.
correct?
Yeah, please.
Yes, Your Honor. So I don't believe that the GPS is necessary in this case. Mr. Clark does not have a history of any kind of violence. This appears to be a incident that occurred or that is allegedly occurred. It just doesn't seem appropriate in this case for the GPS tether. Mr. Clark is showing up at court proceedings. You know, Mr. Clark is generally an upstanding citizen. I just don't see the purpose for this.
All right, thank you. Mr. Pfeiffer, any response?
He's accused of breaking into the victim's home and assaulting the victim. This is an incident of domestic violence. I think that GTS tether is the bare minimum that is necessary for such bond.
I think at least until the prelim, we can revisit this at the prelim, but I'm going to leave Judge Buchanan's no contact order in place, and then we can revisit this next week. There is a no contact order with victim notification and a third party contact minor child in place by Judge Buchanan. I'm not going to modify that until I know a little bit about more of the case or I hear some of the proofs in this matter. So at this point in time, Mr. Driscoll, your motion's denied, but we can revisit it at the prelim, all right?
Thank you, Your Honor.
Right. Anything else for the record, docket 23-00353, Mr. Pfeiffer?
Not from the people.
Anything, Mr. Driscoll?
Not at this time, Your Honor.
All right, thank you. We'll see everybody back here on March 3rd at 8:30. Thank you for your appearance today, Mr. Clark.
Thank you.
Thank you, Your Honor.
And we should be all set on that file. Thank you, Mr. Pfeiffer. Now you can go on to another courtroom. Mr. Clark, yep. There you go. Right, we're on the record in docket 22-00887. People of the state of Michigan versus Jeffrey Jones. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Kristen Rolfe on behalf of the people.
Good morning, Your Honor. Jacob Sartz, the fourth assistant public defender here on behalf of Mr. Jones. Mr. Jones is presently seated at council table.
And sir, you are Jeffrey Javon Jones?
Yes.
All right. This is the time set for a PA 53 contempt hearing. Ms. Rolfe, how are we proceeding?
Your Honor, it's my understanding a defense wishes to arraign the defendant today on this violation and then set this for a hearing at a later date. I will say for the record, we do have Detective Peter Scacia here to testify, but we do not have the jail calls. I understand Mr. Sartz is looking for, so we do not have this at this time. We could certainly get them to.
Okay. So I have PA 50 violation required, dismissed custody. Mr. Sartz, is that your understanding?
Correct, Your Honor. Prior to, just important to clarify in terms of the timeline, these alleged calls occurred after Mr. Jones had pled, according to the report that was turned over. You know, at this point, the extent of the discovery I had received was a copy of a supplemental police report. Certainly, I would like the opportunity to listen to these alleged phone calls. Mr. Jones would like the opportunity to listen to these alleged phone calls. I would respectfully request, Your Honor, that Mr. Jones just enter a plea of not guilty to the violations at this point, that we set this for a contested hearing on April 11th, which would match up with Mr. Jones's sentencing date on the original file. And that way, if Mr. Jones is convicted, or if we work out something, Your Honor would be in a position at that point to sentence him on both matters on that day.
Ms. Rolfe, any comment?
None, Your Honor. I would defer to the court.
Look at this. January 2nd. Was dismissed on January 26th.
Correct, but the alleged calls here were at the end of January, early February, so
Right.
after Mr. Jones had fled.
All right.
And after Your Honor had revoked his phone privileges as well.
Right. All right. I don't see any, and Mr. Jones is in custody on which case, on this case?
He's serving sentence, Your Honor, for a probation violation as ordered by Judge Jamo. And I believe he's not posted his bond on this file, but we're set for sentencing on April 11th.
All right. What's April 11th? All right. So let's set, I think that's a good idea to set it all on April 11th. Okay. So, so I will arraign him on these, let him know the notice concerning the violations on this file. And then we'll set it along with the sentencing on your other file per your attorney's request. The allegation is that after that you were served on June 19, 2022 by a magistrate in Millmore, that you were not to have any contact with Jamila McCoy. It appears that there were phone contacts made after that, but were made before you pled, that were the basis for this no contact, that were the basis for this PA 53 violation. So I'm going to go ahead and set it so that your attorney can get all the information to see when that happened and how that lines up with the court's orders. And then we're going to set it for that same sentencing date. But do you understand the nature of the allegations brought against you?
Yes, I do.
Right. Do you have any question in that regard?
No.
All right. So we'll set this for hearing on April 11th. We have a time for that? 1:30. And that's to coincide with the sentencing date of April 11th. Also 1:30, I would assume. And in the meantime, your attorney can take a look at the discovery and indicate what your various defenses are, okay? All right. Anything else for the record, docket 22-00887, Ms. Rolfe?
No, Your Honor.
Anything,
Mr. Sarts?
Nothing further, Your Honor.
All right, thank you. So keep in contact with your attorney, okay? All right, thank you.
Have a good day.
You too.
And then, Your Honor, if I can just make one phone call, and I think we're ready on Stanley.
Okay.
So you go to this park quite a bit, correct?
Correct.
Are you there to purchase drugs?
No, I was working in the Porter building across the street as a home health aide.
Okay. Have you ever been charged with assaultive behavior before?
Objection to relevant.
Response?
Your Honor, it goes to credibility. She's threatened to assault the prosecutor, and now my position is she's lied about it.
Right. I don't see any self-defense claim here. I mean, I think the only type of character that would come in under some type of 400 character defense, and I don't see any of that here, so I'm going to sustain the objection.
Thank you, Your Honor.
No further questions, Your Honor.
Any redirects?
Yes, Your Honor. Just for clarity for the record, Ms. Owens, there are 3 incidents that we are discussing that occurred between you and this defendant. Is that correct?
Correct.
Okay. And was the first incident, I guess we'll start maybe with the closest in time. Was the first incident on January 5th?
No,
Well, or well, chronologically, when was the first incident?
the first incident was the end of December.
Okay. Do you recall a specific date?
I don't.
Do you recall if it was around Christmas?
It was after Christmas. I know my mom passed away December 27th. So, and it was like around the 27th or the 28th, I believe.
Okay.
New Year's was right around the corner.
Right. And so that was the first incident. For the second incident between you and this defendant, what was the date for that? Do you recall?
I think that was like January 4th.
Okay. And then was the third incident on January 5th, 2023?
Yeah. Or yes.
Oh, you're fine.
You're good.
Okay. So when we're talking about 3 separate incidents, those are the 3 dates that you're referring to.
Yes.
And for the first incident, at that time, was this defendant known to you?
Did not know who he was.
Had you seen this defendant before at that first incident at the end of December?
He had just rode past my car a few times prior to the incident, but I have never saw him before that day, no. And just like maybe 30 minutes before the incident, I saw the car riding by, so then that's why I rolled the window down, because he had stopped by my car, and then that's when the situation began.
Okay, so when you say that he rode by your car, what was he doing? Was he in a vehicle, on a
He
bike?
was in his vehicle, riding by with the window down, like looking towards my car. And I was in the car with 2 friends, and he rode by a few times. So after like the 3rd time, I just rolled the window down, like, can I help you? And he just immediately got to, no, you can't help me, you faggot bitch, and da 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 da. And I said some words that.
Let me stop you right there. So what you're talking about right now, what incident is that in reference?
This is the incident in December. This is before he came to open my door with the ski mask.
Okay, so I guess my question is even before that. So before the December incident, had you seen the defendant at all?
I have never thought of it before.
Okay, so your very first time ever seeing the defendant was at the end of December 2022.
Yes.
Okay. Now, at that time, did you know who he was?
No.
Did you know his name?
No.
And you said that he approached, well, you said that he was, I think you said in his vehicle? Is that a yes?
Yes.
And where were you seated?
I was sitting in my car. I was parked in my car along the street right here. I was sitting on Townsend. I was facing Kalamazoo on Townsend, and he was coming from Kalamazoo facing Townsend. Like, we were sitting like this. I was in my driver's seat, he was in his driver's seat. Like,
So the cars were next to each other?
yeah, kind of. Not far apart.
Okay. And you said during that incident, he had a ski mask on?
not when he initially was riding by, he just had glasses on and like a hoodie, I believe. But I couldn't really still tell who he was or anything like that at the time. We exchanged words, and about 5 or 10 minutes later, he came back to my car with a ski mask on and opened my door with the gun and was like, "No, like, bitch, I should kill you," da, 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 like just going. And I'm like, "So you're gonna kill me right here, like in front of the police station on these cameras? I don't care. You're lucky you got people in the car," is what he said to me.
Okay. So during that December incident, do you know, and it's okay if you don't, do you know if the person that was in the car is the same person that was wearing a ski mask that came up to you?
I do.
Okay, how do you know that?
Because the glasses, the voice, and once he walked away from my car, he went and got back in the same car.
And then was that the end of your interaction for that December incident?
No, he got in his car and rolled back past my car and spit towards my car, and I threw my drink that I had at his car, and then I just like skirted off.
Okay. And so after that incident, were you were not able to identify him by name?
After that incident, I did not know who he was still.
Okay. Okay.
But I could tell you like what I remember from his appearance.
Okay. So let's now move to the next, the second incident that you've referenced being on January 4th of 2023.
So after that incident, New Year's had went by a couple days. I went to work. I came back downtown. I was sitting at the store. I was parked.
Well, hold on one second. So no, you're fine. Just because you have testified initially, so I'm not wanting to go over the entire direct testimony. I know that you've already established the assault and things of that nature on the record. I'm more focusing really on the identification of these incidents. So when it comes to the second incident, when you made contact with the defendant, did you know that that was the same individual from the December incident?
Yes.
And if so, yes?
Yes.
If so, how?
Because of the same car, the same, I remember his eyes, his glasses, his head shape. I just remember from that, I couldn't get that day that happened in December off of my mind, so I remember.
And so, and from the end of December 2022 to January 4th, 2023, that's approximately 1 week, is that fair?
Yeah.
Did the defendant have a ski mask on in the second incident on January 4th, 2023?
No.
How close did you get to the defendant on that day?
Not close at all. I was sitting parked and he began to ride by and roll his window down, and I saw like the gun come up, and I skirted out of the parking lot and I called the police.
Okay. So did you get within 10 or 15 feet of him?
So I was sitting at the end of the parking lot and he was in the street. So I guess I could have been like right here and he could have been like a little further than that wall right there.
So from the witness chair to the wall of the courtroom?
He was still, he was still in his car in the street, and I was in my car parked at the end of the driveway. And once I saw him and once I saw the weapon, I just skirted out of the parking lot. Like I didn't stay to let him get close or anything like that. He had already been telling people that he was trying to kill me. So once I saw the
Objection,
car,
Your Honor.
again, I was
Hearsay.
Okay, sustained. Well, so for the record, I'd say about from where the witness to a little bit past that wall, 20 yards, 25 yards.
Could be a
Or
little
feet.
farther.
Feet would probably be 60 feet, 50 feet or 60 feet.
I believe so, Your Honor.
What's that?
Yeah.
I think so, Your Honor.
Are you talking about this wall here?
I guess maybe from
Or
like
the-
here to there would be like
Okay.
a better distance.
To the back wall, I'd say 60 feet.
I would agree with that. Your
All right.
Yes, Your Honor.
So the record reflects 60 feet from where the witness is sitting to the back of the courtroom.
Honor. Okay. And how long did you have the opportunity to view the defendant on that January 4th incident?
Your Honor, a lot of these questions were already asked at the initial thing, and she's testifying differently now, which I'm going to use to ask questions, but a lot of this stuff is just asked and answered already.
Oh, so asked and answered. I'm going to allow a little leeway since this is a second hearing and this was not the original lawyer on it. And this goes to ID, which I think the attorney's trying to make a point that the identification in regards to several occasions happened over the course of several weeks or a couple of weeks between incidents. Would that be fair?
That is fair, Your Honor. I'm really just trying to establish, how this defendant was, or how this victim was able to identify the defendant. I'm certainly not trying to rehash everything that was
Right.
already testified to. I really am trying to limit it just to the identification.
All right. As to identification, I think it's valid. I'll overrule the objection. You may continue.
Thank you, Your Honor. Ms. Owens, I think my question was, how long would you say seconds or minutes that you had a chance to view the defendant on January 4th, 2023?
So once I seen the car coming, I was already alert because I remember the car. Once he pulled up and rolled the window down, I knew it was him immediately. Once I saw the gun, I was already in motion.
So was that seconds or minutes, would you say?
I knew he was within seconds of seeing him.
Seconds. And then on the third incident that happened on January 5th, 2023. On that day, did you know who the suspect was?
Yes,
How did you know?
from the previous incident. Well, when he was standing outside of my car the first time with the ski mask and walking away, I got to see his body structure and things like that. And once I saw him the second time and the third time, I knew who he was because of the previous incident. I don't know. I'm sorry. I don't mean I don't know. I knew who he was just because I know.
So on January 5th of 2023, did you have, were you able to get close to the defendant? And if so, how close were you?
That day I was sitting in my car and he was running towards my vehicle from behind, and my cousin was there and she said, go, 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 here he comes.
I don't want.
I'm sorry.
No, it's okay. There's just certain rules. We can't talk about what your cousin said.
So I knew it, again, I knew it was him because I was able to turn around and like back up out of the store. And I immediately called the police again and I hit a U-turn in the street and I waited on the phone
So
while he was.
Let me stop you right there. So you said that he running up on your car and you were able to turn around and look and see him.
As I was pulling out, I could see him coming towards my car, yeah.
Okay. And on that third incident, on January 5th, 2023, were you able to describe physical description of the defendant?
On January 5th, I knew who he was because of the previous incident. I didn't know his name yet, but I could identify him from the two other times.
Right. Did you provide a physical description to the police?
From what I knew, yeah.
What was the physical description that you provided?
I believe just like the glasses and the bald head.
Did you describe anything that he was wearing?
A sweater. He had like a hoodie on that day.
And is the person that you see here in court the same person that you saw during the judgment?
Yes.
How do you know that?
Because I remember his eyes and his glasses, and I remember his head. I remember his structure. I remember him.
Nothing further, Your Honor.
All right. Any objection? We've had some ID made, but this is an identification as to all three incidents. So for the record, the witnesses identified the defendant You probably have credibility, cross-examination, once again, that you want to get to.
Yes, Your Honor.
But she has identified the defendant as the individual in all three incidents.
Yes, Your Honor, I'm sorry. I could have cleaned that up more nicely. From the notes, it looked like Mr. Weesty had established identification for the record.
I think he had as to the last two, and the first one was still at issue.
Oh, I'm sorry, Your Honor. Then I would ask the court for the record to reflect
Okay,
identification. of the-
and it does. And this is, this is just a matter of making sure that we have some correspondence between the first preliminary examination and this preliminary examination. I'll allow Mr. Etheridge to cross-examine on the last direct examination. You may proceed, Mr. Etheridge.
Thank you, Your Honor. Going back to the December incident that you say is around December 27th, I believe. You're now testifying that the person had glasses and a hoodie, correct?
Yes, he's had glasses on
And
every time.
it's simple yes or no question. And that seems pretty important that you would tell the police officer that, correct?
Yeah,
And the police officer didn't put it in his report, probably because you didn't tell him, correct?
on what report?
The December report regarding the December
I'm
27th
gonna
incident.
object. This witness lacks personal knowledge as to what the officer.
I think this witness lacks personal knowledge as to what was indicated in the report. So she only knows what she said. That's all she can testify to. The officer can testify as to what was in or was not in the report because he wrote the report.
And you testified that the individual, you had contact with the individual in a car twice, correct?
That yes, ma'am.
I had contact with, he approached my car with a ski mask on one time. Every other time I was in my car trying to get away.
But on the 27th, you testified earlier that you had two contacts with him, correct?
Correct. Yeah, he did pull up on my car, then came back with the ski mask. Yes.
And again, if you would have reported that to the police officer, it should have been in his report, correct?
Well, that's why I'm asking you our report, because this was asked to me after I was even brought to court.
On the January 4th incident, I understood you to testify that he wasn't in a ski mask at that time.
He was only in a ski mask once, correct?
But at your preliminary testimony, you testified that he was in a ski mask, correct?
No,
In fact, I asked about that several times.
I said he was in a ski mask on the December incident, never in January.
Ma'am, we didn't even have testimony about the December incident until today because we didn't have a report to discuss
Well,
the
then the ski
December.
mask shouldn't be brought up because that's when he had the ski mask on in December.
I asked you about the ski mask on the January
And I
4th
thought that was the
incident.
reason why this was adjourned,
Right.
because we didn't have the
All right.
report about
So-
the ski mask.
So just ask a question and answer the question. Don't answer the question with a question, okay?
But I don't-
And
I don't-
I would also indicate, council, just keep it as a simple
He's like
question
trying to
or
like
else,
trick
ma'am,
me, like that's weird.
Yeah, well, just answer the question. We'll get through this if you answer the question. If you fight with council, we're not gonna get through this. And then we're gonna have to take a
So he had
timeout.
ski mask one time in December.
So when you testified at the last hearing, when we were having testimony for the preliminary examination, and you testified to this judge that the person was wearing a ski mask, you were lying then?
I didn't say he had a ski mask on January 4th.
You testified at the last hearing, the individual had a ski
I
mask.
think she answered your question, council.
You also testified that there was a black gun, correct?
Correct.
Now today, on the regarding the January 5th incident, you're testifying that he ran toward your vehicle, is that correct?
And he did, yes.
That was the, excuse me, going back to the 4th. Night was very,
Sorry, just for the record, is that a yes?
Yes.
and the weather that night was really bad, correct?
No, it wasn't really bad.
There was no snow or rain or anything that night?
It was wet the ground was wet, but at that time it wasn't raining. He chased me down Washington going 100 miles per hour, so I don't think the weather was that bad.
Have a minute, Your Honor.
You may.
And your testimony today is that you're able to identify this person based on each incident, correct?
He's the same person from each incident, so I can identify him, yes.
And the January 5th incident would be the last incident, correct?
Yes,
And during that investigation, when you met with Officer Clue, numerous times you told Officer Clue you cannot identify the person, correct?
I told him I didn't know who he was as far as his name. Like, I didn't know specifically, but I could tell you what he looked like, yes.
You said you couldn't identify him, you never seen him before in your life, correct?
I said that the second time because I didn't see him. No, that's not what I said.
We've taken quite a long break between this hearing and the last hearing. Who have you talked to about this case since then?
Just the officer that called my phone.
Have you talked to anybody regarding the identification?
No, haven't even been around the park or anything because I've been scared because he's still out here.
Have you talked to any law enforcement or the prosecutor or anybody about the identification?
No.
No further questions, Your Honor.
Any redirect?
Nothing, Your Honor.
All right, without objection, may this witness be excused from people?
Yes, for the people, Your Honor.
Defense?
Yes, Your Honor.
All right, this witness is excused. Ma'am, thank you for your appearance today. The people have further proofs.
Yes, Your Honor. At this time, the people would call Officer Christopher Mosby.
All right, officer, I'll have you come straight up here. And then please state your name, full name, and spell your full name for the record.
Christopher Mosby, CHRISTOPHER, Mosby, MOSBY.
All right, thank you, sir. Remember, have you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I swear.
Okay, thank you. Have a seat and project to the back of the courtroom for recording purposes. Counsel, you may proceed when you're ready.
Thank you, Your Honor. Can you please state your name for the record?
My name is Christopher Mosby.
And sir, how are you employed?
I'm employed at the Lansing Police Department as a police officer.
How long have you been employed
I've
at the Lansing Police Department?
been employed at the police department for about a year. I've been a police officer for about 8 months.
And do you have any special assignment? Were you working in your capacity as a police officer with the City of Lansing Police Department on January 5th, 2023?
Yes, ma'am.
And what shift were you working that day?
I was working noon shift as a patrol officer.
And did your duties as a police officer bring you to the location of 428 South Washington in Lansing County of Ingham?
Yes, ma'am.
And what brought you to that location?
I was sitting down the street and there was a call that came out over the radio over an incident involving a weapon at the downtown party store.
Okay, and where is the downtown party store in relation to 428 South Washington? Or is that the address of the party store?
I think that's the address of the party store. It's at the corner of Washington and Leather Way.
And you said you responded to a weapons complaint?
Yes, ma'am.
And were you provided with an identification of the suspect?
Yeah, so the initial dispatch information was that there was a person in burgundy pants, burgundy sweatpants or something like that.
And when you arrived at that location, what did you observe?
When I got to the location, there was a Ford Flex with several individuals standing outside of it, and then one of them matched the description of someone wearing burgundy sweatpants.
Approximately how many individuals were standing around that Ford Flex?
It was about 2 or 3.
And how many people had burgundy pants on?
Just one.
Do you recall if the previous identification stated the suspect was a male or a female?
It was a male.
And was the person that you saw in the burgundy pants a male?
Yes, ma'am.
And after you observed the two
Initiated a felony stop due to the incident involving a weapon and have them get on the ground and put their arms out.
did you then detain the person in the burgundy pants?
Yes, ma'am.
Do you see anyone in the courtroom do you see the person in the courtroom today that was wearing the burgundy pants during this incident?
Yes, ma'am.
Can you please point to him and describe something that he's wearing?
He's wearing a blue surgical mask.
And where is he seated?
He's seated at the defense.
Thank you. Your Honor, may the record reflect the identification of the defendant.
Any objection?
Did he have a blue face mask on when you ID'd him at the scene?
Sir?
Are you able to ID him right now with this mask on?
Yes, sir.
For preliminary examination purposes, Your Honor, I guess I'll not object or agree to it, but.
All right. So without objection, the witness is identified the defendant.
Thank you, Your Honor. And did you detain the defendant?
Yes, ma'am.
And where did you detain him?
I detained him near the rear of my patrol vehicle.
At that time, was he away from the other individuals that were around that Ford Flex?
Yes, ma'am.
And after you detained him, did you put him in handcuffs?
Yes.
And then did you confront him with the reason for the call and the incident, the reason that you had gone to the party store?
Yes, and then I asked, "Where do you have a weapon on you?" And he told me that it was in his pocket.
Okay. Was that one of your preliminary questions to the defendant?
Yeah, just because of what we had going on and just making sure for the safety of everyone involved, secure firearms for his own.
And so you asked him if he had a firearm and he said yes?
Yes.
And then what did you do next?
I secured the firearm.
And where was that firearm located?
It was in his front right jacket pocket.
And can you describe the firearm that was located?
It was a 6-shot revolver.
Okay. And then after you located that revolver, did you place the defendant under arrest?
Yes, the defendant was under arrest.
Did you read the defendant his Miranda rights at that time?
Yes, ma'am.
And can you please tell me about that? How did you read him his Miranda rights?
I read him his Miranda rights for my LPD advice and rights card verbatim.
And after you read the defendant his Miranda rights, did he agree to speak with you?
Yes, ma'am.
And what did the defendant tell you when asked about having the gun?
He was just saying that he was a CPL holder and that he had no reason to threaten anyone with it. He was just carrying it to be a CPL holder.
Did you independently verify and lean if the defendant was in fact a CPL holder?
Yes, ma'am.
And what was the result of that search?
That he did currently have a CPL.
Did you ask the defendant after Miranda if he knew the victim Darian Owens?
Yes, ma'am.
And what was his response?
He said that he did not do that.
Did not know. I'm sorry. Did not know who he was.
Yeah, didn't have like any formal relationship with him.
But the defendant, you said, denied threatening somebody with the gun?
Yeah, denied threatening.
Were you given a description of the suspect vehicle involved in this incident prior to you arriving on scene?
No, I did not have a description of the suspect vehicle.
And then Did the defendant tell you anything else in relation to this incident?
No, ma'am, he just said he was going to the downtown party store to get something from there.
And then after your, after the defendant's statement, then did you take him from the scene, or what happened next?
Yeah, then I took him to the LPD jail to be booked in.
And then, Officer Mosby, after you booked the defendant into the city jail, did you do anything else in relation to this case?
I took photographs of the clothing that he was wearing at the time.
And what was the clothing that he was wearing at the time?
He was wearing burgundy sweatpants, I think a tan t-shirt, and I think it was matching a burgundy sweatshirt as well.
And then-
It was a tan sweatshirt.
And then looking, did you, were you the one that went and recovered surveillance footage of this incident?
I contacted the crime analysis and she was able to pull surveillance video from the building right across the street from the downtown party store.
Okay. And did that surveillance video show anything related to this incident?
Yes, ma'am.
And do you recall what it showed?
Your Honor, just to clarify the record, could we put which incident we're talking about?
Still think we're talking about the January 5th incident.
I'm sorry, and I will, yes, the January 5th incident, Your Honor.
Well, I didn't receive any video as far as I know from the January 5th incident. There was video provided from the 4th, or maybe I'm backwards. Is it the 5th? Did I have a second to check?
From his report.
Okay. No objection, Your Honor, to the question. I did get the 5th, but I didn't get any for the 4th.
All right. With that understanding, you may answer the question. You can restate the question if you'd like.
Thank you. And did the surveillance footage show anything that occurred during this incident, like such as cars, things like that, individuals?
Yes, ma'am. So just prior to the incident, saw a white Ford Focus going southbound on Washington, approached the intersection near South Washington and went away, and then it reversed and then parked in a parking spot right in front of the downtown party store. And then an individual that was consistent with Mr. Williams' appearance got out of the vehicle and then approached the white sedan victim's car in the back parking lot of the downtown party store and started running towards it. And then the other car pulled off, and then Williams started walking towards the Ford Flex where we found him when we responded like a minute later.
And how did this occur at night?
Yes, it was darker outside.
And then did you tag the firearm into evidence?
Yes, ma'am.
Nothing further, Your Honor.
Cross-examination.
So you tagged the firearm into evidence, correct?
Yes, sir.
And the evidence that you tagged in was a silver, silver pistol revolver, correct?
Yes, sir.
So the firearm for these incidents was not black, correct?
No, sir.
Now, you testified about a video, and you testified about a lot of stuff you could see from that video.
Yes, sir.
If I show you the beginning of the video, would you be able to identify the video that you watched?
Yes, sir.
Let the record reflect that the attorney is approaching the witness in order to confirm that they're talking about the same video.
This is the video that you saw, and that you were referring to during your testimony, correct?
Yes, sir.
So you confirm that is the video that we're talking about?
Yes, sir.
Okay.
And the prosecutor, you've seen this video, correct? Is there any objection to the video going into evidence? This actually accurately depicts what you observed, and this is the video that you saw.
Yes, sir.
No objection.
All right. So this video is actually
without objection. Do we need something to mark to make this as an exhibit?
Yes, Your Honor.
We typically get these digitally, and I've in the past just had them entered without marking them or saying it's the video.
I mean, it's just hard for the court recorder to indicate that it's been. We need like a flash drive or something marked to indicate that it is what it purports to be under 901. If there's no objection, we can proceed with the understanding that there's nothing tangible to mark.
Well, I could ask him, we could do that, Your Honor. I could ask him questions about it regarding.
Absolutely. If there's no objection, we're all working from the same video. We just don't have anything to mark and admit into evidence at this time.
So, Your Honor, and I don't know what you wanted to even do that after, at a later time, or I really have no objection though to however.
All right. So there's no objection. We can talk about the video. If there's no argument, we're all talking about the same video, that's fine. So, Mr. Etheridge, you may proceed. I just wanted to clean it up because we don't have anything tangible to mark that would go into evidence at this time.
And this video was taken from a high altitude, correct?
Yes, sir.
And it's a very far distance from where this alleged incident occurred, correct?
Depends on what you mean by far.
Do you know the distance from the camera to where these cars in the store is?
No, sir.
By looking at the video, the cars and store is very small, correct?
I wouldn't say so.
Well, the video, it also depicts or shows that it was wet and raining out, correct?
Yes, sir.
The video at about 6:51 shows a white car, what appears to be a white car, pull in front of the downtown party store. Is that correct?
I can't see the timestamp of the video, so I can't tell you. About 6:50.
And looking at this video, you cannot tell who's inside of this car, correct?
Sure.
At around 6:53, the video shows people walking along the sidewalk, correct?
Yeah,
And you can't identify what type of clothing these people are correct, are wearing, correct?
so there seems like there's like a black pants and some type of lighter colored hoodie.
And this video is in black and white, correct?
No,
It's dark time, so the video is dark, correct?
yeah, the video is dark, but it's not in black.
And then there's a lot of lights coming from the store that's reflecting off the different things, correct?
Yes, sir.
And light reflecting off of different things can make the color appear to be different colors, correct?
Possibly.
But you couldn't identify these two people walking, correct? Because they're so small on the video, correct? You can't really even tell if it's male or female, correct?
It looks like fruit nails, sir.
But you can't be sure of that. You're just assuming or believing it is. I mean, you can't tell really.
Is that a question?
Correct?
Yes.
And I scrubbed all the way to the end of the video.
Mhm.
I don't see where this other car pulls in over here.
So if you see right there, that's the victim car and she's pulling off. And then the accused walks back over here to the Ford place. And then it should be noted that car registers to Mr. Williams as well.
Okay, well, that wasn't a question, but
Okay.
that's the car that Mr. Williams was in when you arrested him, right?
No, sir. Mr. Williams is in this car.
But you said that that was his car, and I was saying that that was the car that he was in when you arrested him, or he was in this car?
No, sir, he was standing around this car.
Your Honor, I think we need to make the record a little clearer here, saying this car is very, you know, if we could just have more descriptions for what they're talking about.
Yeah,
you know?
saying, so if we could use a descriptive element other than car, like a make and model of the car, I think that would be helpful for the record.
Yes, sir.
No, I don't think you can make out the make and model based on the video. We can give a time stamp. At around 6:52, the car parked in the front of the downtown party store in a parking space that appears to be white is the car that you referred to as the suspect's car, Mr. Williams' car, right?
Yes, I refer to that as the car that he registered to Mr. Williams.
And that's a timestamp 6:52:37. Now the car, but you can't really see anything but the headlights at 6:52:57 is the car that you're claiming is the alleged victim's car, correct? This car?
Yeah, in the corner. Yes, sir.
And all you can see basically is the two headlights as it's coming down or driving in the parking lot to what would be east, correct?
Yes, sir.
But you can't identify that car, correct?
Well, it's a white sedan.
You can't tell by the video it's a white sedan, correct?
Oh, I can't, sir.
And when it's turning here, it appears to be white, correct? It's 6:53:01. And around 6:53:05, there's numerous people walking around in that area, correct?
In which area are you referring to,
In
sir?
front of the car that you said was the defendant's car and in front of the party store area, parking lot area, right in this area.
Yes, sir.
And you can't identify any of these people, correct? You just see small people walking on the video or moving around on the video. There's no way you can identify them, correct?
I would say no way. If I had more, to go on, like saying this person went in this yellow hoodie, I wouldn't have that information possibly I could identify.
But right now, sitting here today, looking at it, there's no way you can identify these people, correct?
Possibly not.
And you testified that one of these individuals you believed was Mr. Williams coming back to the car, correct?
One of which individuals, sir?
One of the individuals that's over here walking around.
No, sir. It's one of the individuals near this Ford Flex over here in the parking lot, if you could see.
I can't really see it.
Yeah, so you can see there are people gathered around this vehicle right in the parking lot.
And whose vehicle is that?
I don't know, sir.
And you can't identify any of these people around this vehicle either, correct?
No, not at all, sir.
For the record, what timestamp is that?
Around 6:54:12. And there's no video from there to the end of the video. It really doesn't show anybody running toward or away from that vehicle. They're all just standing around talking, correct?
Running away from the vehicle?
Yeah, you testified earlier that the person was running away from the vehicle back to his vehicle, is my understanding.
I stated that Mr. Williams ran from his vehicle in front of the downtown party store to the victim's vehicle and then started walking back towards the Ford Flex. It's in the parking lot. Like right there.
And that's at 6:51:55.
Yes, sir.
Now, you never had contact with the alleged victim, correct?
No, I did not, sir.
And she was never so she was never in any way attempted to identify the person to you, correct?
Not to me, sir.
And again, your testimony is the gun that was used is a silver gun, correct? Not a black gun.
Yes, sir.
No further questions, Your Honor.
Any redirect to this witness?
None, Your Honor. I would just ask that the exhibit be published with the court. I don't know if the court very well could have already seen the exhibit, but in the event that the court has not.
Yeah, I know, I've had nothing marked. This has all been by stipulation. So if you want to have if you want to have the exhibit shown, for all of us to see, we could publish in that way. Is there any objection to that?
No, Your Honor, we talked about it and timestamped it also.
All right. So let's just play the video. Can we put it on the main and just HDMI? All right. Because I kind of saw it, but I kind of didn't. But since I'd like to see what everybody's talking about. All right, so we're watching the previously stipulated video that was used for direct and cross of the officer. All right, so the video's been played. I think the final marking point was in the 654 region. Is that fair?
Yes, sir, Your Honor.
All right. So cross-examination has been complete. Any redirect?
None, Your Honor.
Any, may this witness be excused?
Yes, Your Honor.
Any objection, Mr. Etheridge?
No, Your Honor.
All right, so the witness is excused. Thank you for your appearance today. And the people may call their next witness.
Your Honor, our next and final witness, the people would call Christopher Clue.
No.
You can go ahead and pull that HDMI.
Your Honor, I was just getting ready to,
All right.
setting it up for a video that we're gonna play.
Okay. What? You can pull the HDMI cord, I guess. It's bothering Wendy.
Don't you want him to go right up to the?
All right. Oh, right here. All right, please state your full name and spell your last name, your full name.
Christopher Clue, CLEW.
Okay. Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. Have a seat, project to the end of the room for recording purposes, and counsel when you're ready to proceed.
Thank you, Your Honor. Can you please state your name for the record?
Yes, Officer Christopher Clue, CLEW.
And how are you employed?
I am a road patrol police officer with Lansing Police Department,
And how long have you been so employed?
about 4.5 years.
Do you have any, aside from road patrol, do you have any other special assignment?
Yes, I'm also a member of the Capital Area Dive Team as well as Special Tactics and Rescue Team, our tactical team.
Were you back on January 5th, 2023, were you working in your capacity as a police officer?
Yes, I was.
And did your duties bring you to the location of 428 South Washington, City of Lansing, County of Hingham?
Yes, it did.
And can you tell me why you responded to that location?
The original dispatch information was for a weapons complaint for a gentleman out there with a firearm, threatening people with it.
And when you arrived on scene, did you make contact with the victim?
Yes, I did.
And do you recall the victim's name?
Darian, I can't recall the last name at the time.
If I were to tell you Owens, would you have any reason to disagree with me?
Nope, that's it.
And when you made contact with the victim, Darian Owens, was that right there on scene?
Yes, in the immediate vicinity. They were parked in their vehicle approximately half a block to a block west of the scene that other officers were working at the time.
Okay. And without telling me what the victim said, did you take the victim's statement?
Yes, I did.
Your Honor, I have nothing further at this time.
Thank you. Just a clarification. And what date was that?
January 5th, I believe.
January 5th. All right. Cross-examination.
Thank you, Your Honor. Officer Clue, isn't it true that you spoke with this alleged victim numerous times that night?
Yes, I did.
And every time you spoke with her, she could not identify the person that allegedly committed the crime, correct?
She didn't know the individual by name.
But she said that she couldn't ID. She'd never seen him before, correct?
That's incorrect. She said she had seen him before in previous incidents, but again, wasn't able to identify him by name, but knew him by face and character.
Previous time she's seen him, she had a ski mask on, correct?
She said that she had seen him multiple times. The incident the night before, she stated that he was wearing a ski mask while inside the vehicle, but she also stated that she recognized the vehicle from the night before as being the one that he got out of and ran towards her vehicle that night.
Okay. I guess I might have to ask a little bit more direct questions because you're answering questions I'm not even asking, but you did bring up a good point. She said on January 4th, he was wearing a ski mask, correct?
Yes.
And during this investigation, you determined that Mr. Williams had a CPO, correct?
I was not the officer that was involved in locating the firearm on him, running his information or verifying his CPL, so I can't answer to any of that.
You had contact with the gun, correct?
Very briefly, it was handed to me during the felony stop, and then when safe to do so, I immediately handed it over to the officer that was handling the situation.
And did you come back and get the gun from that officer and tag it into evidence, place it in a plastic bag?
I did not. It was given to the officer to handle for evidence.
And that was a silver revolver, correct?
I believe so.
And during the investigation of this crime, several of the officers stood around regarding the January 5th date, correct? And was discussing the case, correct?
That's correct.
And at that time, you guys were saying there was no crime at that time, correct?
We were trying to figure out exactly what we had on scene. I mean, it was a dynamic situation, so we need to sit down and actually think through
what is happening and what we have. It's not correct to make snap judgments and immediately start arresting people and writing reports off of initial instincts. So in my professional opinion, it's good to.
Okay, well, let me ask you this. You've learned how to testify, correct?
I've testified several times in court.
Okay, what's the relevance of that? I mean, we don't have a trier of fact here. There's no jury here. It's
He's
just
not-
me.
He's not
So-
answering the question, he's just rambling on.
But you're asking the question.
And I asked him a simple question of whether or not the group of officers stood there together and they just were, there was no crime, correct? The discussion wasn't. There was no crime.
That, you asked 3 questions in that one question. So that was, I mean, he answered one of the questions, the other 2 he didn't. So if you want if you want a yes or no question, just ask him the question, he'll answer the question. If you're gonna ask several questions along the way, don't get angry when he asks one of the 4 or 5 questions you've asked him.
Thank you, Your Honor. So you guys stood around in a group, correct?
Yes.
And you were discussing the case at that time, correct? This incident.
Yes.
And during that discussion, the group said there was no crime committed, correct?
At one point, yes.
Okay. Are you still stipulating for the video or need for the foundation?
No.
Your Honor, I have his body cam video that we've stipulated to have it played or portion of it played.
All right, so there's nothing to mark, but it's stipulated to, so.
Yes, Your Honor, I just will say for the record, I have stipulated to this with the understanding that Mr. Etheridge intends to use this for impeachment of the victim's statements that she's made, because this officer did take her statement and is on her body cam, on his body cam.
Okay, with that understanding, you can play the video.
Thank you, Your Honor.
All right.
Because I just don't understand why it's taking. Try to find him with a gun.
Yep. So unfortunately, he has a CPL.
I think that it's a little bit farther ahead, Your Honor.
The right reason. He doesn't even know me. He's been chasing me in traffic. He came to my car with a ski mask on, pointing it at me. He doesn't know me. He's telling.
So at around 32:20, she states that he came at her with a ski mask. This is referring to the January 4th incident, and we've had testimony regarding that.
Yep, absolutely. Like I said, I want to make sure that we do everything right and get all the information we need right now to make sure that
What was he gonna say? Like he was defending him. Like
I got some questions for you. I'm just trying to explain it, like, because we don't want to go, oh, he had a gun, this happened, blah, blah, blah.
this is scary.
Yeah, absolutely. So that's why we're trying to do it the right way, and then that way, because I mean, we know what's going on, 100%, right? But the way 100% and there's something wrong. So I just want to make sure I do everything 100% by the letter of the law and get this done. All right. So
I'm about to cry because I don't know what to do. I don't know him. I can't even really tell you what he looks like. Can you tell me his name?
Your Honor, let the record reflect that around 32:10, she says she doesn't even know him. She doesn't even know what he looks like.
Record reflect that she indicated, I really don't know what he looks like. I think that's what she said.
Thank you, Your Honor. No further questions, Your Honor.
Any redirect?
None, Your Honor.
We made this witness be excused.
Yes, Your Honor.
Without objection, the witness is excused. Do people have any further proofs?
No, Your Honor, not at this time.
All right. Any proofs for the defense today?
Yes, Your Honor. The defense would call Taylor Hicks.
Ms. Hicks, you've been in the courtroom
Yes.
through some of this testimony today?
Yes.
All right.
Yeah,
So-
I didn't realize that she was here.
I guess I didn't realize that either.
please.
Your Honor, I didn't either, but she wasn't in the courtroom during Mrs. Owens's testimony, which is what I'm going to ask about.
All right. I just know that she's been in the courtroom for a couple of officers' testimony.
Yes, and I heard the very end of Miss Owen's testimony.
All right. So with that understanding, the witness has appeared to sit through some of the testimony in violation of the sequestration order. However, it comes as a surprise to everybody here. So, all right, I'm gonna have to state your full name and your full name and spell your last name for the record.
Taylor Wicks, TaylorWicks.
Okay, raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Okay, you can have a seat, ma'am. Please project for recording purposes. And Mr. Etheridge, you may proceed.
Thank you, Your Honor. Ms. Wicks, could you tell us where you work at?
I work at Ingham County Office of Public Defender.
And I was trying to look at
Take a brief, there we go. You're fine. All right, you may proceed, Mr. Etheridge. We're just making sure that everybody's ears are still in place.
Thank you, Your Honor. I'm just looking up the date of when we actually had the hearing on January 20th. On January 20th, we had a preliminary examination that started in this courtroom. And we took a break and the witness and the prosecutor went outside in the hallway. So I'm going to ask you about your observations during this time period. Do you recall that time period?
Yes, I was on arraignments that morning, which is just down the hall. The walls in this building are rather paper thin, so I could see and hear everything that was happening.
And did you hear and see the interaction between Mr. Wisty, who was the assigned prosecutor, and the alleged victim, Ms. Owens?
I did. There was a commotion in the hallway, and I stopped talking to the client in lockup that I was then speaking to, walked over to the door, opened it, and stood in the vestibule, I guess for lack of a better term.
So there was no issue with you being able to hear what was going on, correct?
No, I could hear and see clearly.
And this individual was talking extremely loudly, correct?
I'm gonna object to the format. This is direct examination.
I apologize, Your Honor.
Yeah, so we'll ask some open-ended questions. I'll ask you to rephrase the objection sustained.
How were you able to hear, how were you able to hear this, these individuals talking?
So as I was interviewing the client in lockup, I could hear some screaming and yelling coming from the hallway. At that point, I asked the person I was talking to hold on. I muted the computer so the person I was talking to couldn't hear. I stood up and walked out just to see what was going on.
And once you walked out, did you approach the individuals?
No, I did not. I stood just right outside the door. They were at the benches that are in the room. It's probably 20 feet across the room at best.
And since they were so close at 20 feet, and I think you said the volume of them talking, you were able to hear them clearly again, correct?
Yes, I was.
And what did you hear? What did you hear in that discussion?
So the woman was yelling at who I know to be Jacob Wisty through my employment. She was screaming and yelling about you keep letting this mother effer out of jail. She said the actual term. And he keeps doing this to me. Y'all aren't doing your goddamn jobs to protect me.
And did she go on to say anything threatening?
Yes, she told Mr. Wisty that if he kept looking at her with his dead ass eyes, she would be the next one to end up in jail.
Did you hear anything regarding identification issues?
Yes, Mr. Wisty just kept repeating that if
So I'm gonna object. What Mr. Weesey said is hearsay. If this is being used, as I understand, for impeachment purposes of the victim, then surely that's allowed under 608. You know, however, what Mr. Weesey said is not. So this would be only to impeach victim Darren Owens and what she said.
It's my understanding this witness is impeaching the eyewitness, the alleged eyewitness in the matter. But it's unless you lay foundation for another type of exception to hearsay. I don't know if Mr. Wisty fits under that to impeach and not use the substantive evidence.
I can ask specifically about the person being impeached, Your Honor.
All right, so with that understanding, just keep your remarks as to what Darian Owens said. Is that Darian Owens?
It is.
Darian Owens said, yep.
Keeping your remarks to that, what did Mr. Owens say regarding identification?
She kept saying that she didn't know who he was. She didn't recognize him, that she had no idea. Basically just kept repeating she didn't know who he was.
And did without saying what Mr. Wisty said, did he respond?
Yes.
And what did Ms. Owens say in response to that, if anything?
That was when they went back and forth with the same sort of question and answer multiple times, and she just kept saying she didn't recognize him, didn't know it. And then that's when she made the threat to Mr. Wisty.
And during this conversation on from Mrs. Owens' perspective, did she respond to anything about the case being dismissed?
Yes. She was angry that if she couldn't identify him, that this case would be dismissed.
All right, no further questions. Thank you.
Cross-examination?
Yes, Judge. Is it Ms. Hicks?
Wicks.
Ms. Wicks. You said that you think you're approximately 20 feet away.
Yes, I will admit on the record that I am bad at spatial relations, so.
But you were in the door to a room and they were in like the general public area?
No, I exited the room.
Okay, so you were, as well as Mr. Wisty and the victim, were all in the public area?
Yes.
Nothing further, yeah.
All right. May this witness be excused, Mr. Etheridge?
Yes, Your Honor.
May this witness be excused, Ms. Rolfe? All
Yes,
right.
Your Honor.
Well, without objection, the witness is excused. Ma'am, thank you for your appearance today. Does the defense have any further witnesses?
No, Your Honor, thank you.
Does the defense rest?
Yes, Your Honor, thank you.
Motion for bind over?
Yes, Your Honor, I'm in a very precarious position because I don't know what was on the record at the first examination. And so I'm really going to rely on the record. I know the court was present for that portion of the examination, as well as Mr. Wisty's notes in the file. Certainly, I think this case hinges on identification of this defendant. I have not heard any evidence questioning the charges or whether or not, in fact, those charges did occur. So probable cause that a crime occurred, probable cause the defendant committed those crimes. So I would argue that those crimes, there's no evidence those crimes have not occurred. In fact, I think that there's been testimony to support both counts 1 through 4, but carrying a dangerous weapon with unlawful intent. I think that the victim testified, again, from Mr. Wisty's notes, that she testified that this defendant on several different occasions has been approaching her in some instances under his jacket, what she interpreted to be a gun pointed at her. In some instances he had a ski mask on, and others he did not. And then he pulled a gun on her when they were at the party store. The defendant was in his car, the victim was in her car, and he pointed a gun at her. She then drove off. So that would establish the elements for count 2. I think the victim testified previously per Mr. Wisty's notes that she was scared for her life when that occurred. And I think that the record has established that this defendant was carrying a weapon with unlawful intent. This occurs over 3 separate times. Again, with the intent, unlawful intent, and with the intent to commit an assault with a dangerous weapon. So really, this case comes down to identification. Is this the right person? Is this defendant, in fact, the defendant, the person that committed these crimes by probable cause standard? As to the identification, admittedly, it was hard to follow at times, which is why I tried to, on redirect, focus onto the 3 separate incidents so that we can have a better picture of what was going on here. It appears from the redirect that Ms. Owens would not have been in a position to identify this defendant after the December incident. She said that he had a ski mask on, and I think she also said that he was in his car driving by her. So then at that point, I think she testified she really didn't know his name, wouldn't have been able to ID him, did know his description, but wouldn't have been able to ID him. It's only because of the 2 other incidents, so really the 3 in totality, that this victim is now able to say, yes, I know that is the defendant based on my 3 contacts with him now, based, I think she said, on his glasses, on his distinctive eyes. I think she said, but based on his stature, his build, she, I think, was able to identify him because of those 3 incidents. And the first one, I don't think based on the testimony, she would have been able to ID him after that first incident. But again, that incident was not reported to the police at the time, number 1, but number 2, it also does not have any crimes or charges arising out of that incident. The second incident, she said that he did not, she was able to see the defendant. And then in the third incident, she also said that she was able to see the defendant. And I think she testified in both of those 2 incidents, he did not have a ski mask on. So I think really it comes down to identification, really credibility, and whether or not this court believes that this victim is credible, given her statements. I will acknowledge that defense has impeached her, so she certainly does have different statements that she's testified to versus different statements that were listened to and heard in the body camera, what she told Officer Clue. So there definitely are different versions of what she said, but she has seen this defendant on 3 different days. I don't know if she was confusing them or if she was just in the heat of the moment. I don't know what's going on. I don't know who this guy is. I don't know. I think I'll leave that to the court to assess credibility. But if the court finds the victim to be credible, then I think that identification here has been made as to this defendant. So probable cause that these crimes were committed and probable cause that this defendant is the person that committed those crimes. So I will leave it to the court as to the credibility determination on the identification issue. But with that, I would move for bind over on the 4 charged counts.
All right. And Mr. Etheridge, response to the motion for bind over.
No, I asked the court not to bind over. Obviously, I don't believe that the witness was credible, and I don't think the ID is sufficient enough for bind over. Starting with credibility, her testimony changed. It changed throughout the trial. It changed from her preliminary examination. It changed from when she testified the first time. Specifically, I'm going to point out the January 4th incident where she testified he had a mask on. Today, she testified he didn't have a mask on. The officer testified he had a mask on. Regarding credibility, the testimony regarding the incident with Mr. Wisty and her not being able to identify that person then and being told that the case was going to have to be dismissed if she couldn't identify him. That gave her motive to come in and identify him. And then she makes this threat to Mr. Wisty about the cold dead eyes, and she's going to be the next one to go to jail for that. So she specifically said on the record, she didn't say that, That was her testimony. And Ms. Wicks, who's an attorney in our office, was outside doing her job. And because of this big commotion that we heard, and I went outside and asked them to be quiet. And I think they was quiet and moved down some, but she was able to clearly hear what she said. And the victim, the alleged victim here testified that none of this happened. She didn't say any of it. So she is not credible at all. You got 3 different incidents. 2 of the incidents, he's wearing a ski mask. The last incident where he is stopped on scene, he's a licensed CPL carrier. He's not doing anything. He has a right to carry his gun. The video clearly shows that she takes off immediately, so there's no time to even see the guy or whoever's there that's supposed to be involved in this. And I don't see where the video showed him chasing her. It shows him walking back from the parking lot to the car, maybe, and walking to the parking lot. So I don't find her credible at all, and she has not been able to identify the person. The last time, during the last incident, January 5th, Officer Clue has talked to her. He talked to her several times, and I just played the very last clip of her saying she couldn't identify. The court wrote specifically down what she said. So for her to come into court and then all of a sudden say she can identify him, and then we have this break, and then she changes the stories in terms of some of the information regarding masks. We took a break to get a supplemental report about an incident in Ruta Park, and then all of a sudden we get an incident that's near Ruta Park at the downtown party store. And then, the whole point of getting that report, because she could identify him in that report, and then the report says he was wearing a mask. She testified he was wearing a mask. So obviously she cannot identify the person. And on the January 5th incident, he was legally carrying. There's no indication that he actually or the individual there even pulled a gun to even threaten her, because she took off so fast. The video showed her leaving, pulled in and took off right away. So there's no weapon displayed, no threat made. If he had the weapon, the officer found it inside his clothes, in his pocket, where he's legally allowed to carry it. So based on all that information, I do not think this case should be bound over on any of the counts. She's not credible, and she cannot identify Mr. Williams as the person who allegedly committed this crime. And in fact, she was saying that he did the Ruta Park crime. And then all of a sudden, another individual gets charged with a Ruta Park crime that's where she's an alleged victim. And all of a sudden, we're not at Ruta Park now. Now we're back at the downtown party store. So based on all that information, Your Honor, I do not believe the court should bind over. Thank you.
Thank you, Mr. Etheridge. Response to the motion, response to Mr. Etheridge's response to the motion for bind over.
Your Honor, I think it really does boil down to the credibility analysis. So I'll defer to the court as to that.
Well, I mean, the standard that I'm dealing with is preponderance of the evidence. And we know that it's the second lowest standard in criminal law, the highest standard being beyond a reasonable doubt. That much is true. The court also has to consider credibility. And in this case, I have to throw out the December date really completely. Although we've looked at it now, there's nothing that we find helpful concerning what comes down to is identity of the defendant in regards to this. I agree with counsel. This comes down to identity, identity and credibility. Those two things it comes down to. The standard is low, but it is not so low that the court has to just leave its brain at the door on some level. And I just, through the experience of watching the witness testify over the first go round of preliminary examination, and then the adjournment for discovery, and then the second, much better done for preliminary examination in regards to these two dates. It appears to me that there was some question at the charging level whether this occurred from law enforcement. They had some doubts as to what the witness was telling them, how she was telling them, and whether they had a suspect. Now, I do see that I will admit that over the course of time, identity can be made over the course of time. This doesn't happen in a snapshot. But even in this case, I find that with the credibility issues and the identity issues over the course of time, that the people have not met their burden at a preponderance standard. There's simply questions to go to the trier fact that the court isn't willing to bind over to have it looked at by a jury. I think there's credibility issues, immense credibility issues. I do think that there's elements issues here. And so I'm going to deny the motion for bind over. And I'm going to indicate that for our purposes, the testimony concerning the two dates, that preponderance has not been met by the witnesses called, and therefore the case is dismissed at this time. Any questions regarding anything along the lines of any follow-up? Because I know Mr. Wisty's name was brought in. I think he was just in the process of doing his job. So I don't think that there's any tangential, anything in regards to his association. All this was set out of court concerning any credibility matters. And most of what was stipulated to was done for impeachment purposes, as I saw it. Anything else from the people, Ms. Rolfe?
No, Your Honor, and I think, yeah, as it relates to Mr. Weesey, I actually have spoken to him, so he was aware of kind of what's transpired. But I don't think that there's anything that he's done improper or
Right.
any
I don't
allegation
either.
to that effect. I think that he was just doing his job that
Right.
day. So I think that with the dismissal, I think that ends.
All right, Mr. Etheridge?
I would agree, Your Honor, and that was a very difficult alleged victim that he was dealing with, and I know stuff happens, and I don't think he did anything improper. And he was trying
I think that was on the course of
we just
doing
trying to handle the
business, right?
situation of his job.
All right, thank you. So with that understanding, the court refuses bind over on the matter. Preponderance has not been met, and the case is dismissed.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, I just wanted to apologize to the court. I did not realize there was a sequestration order.
That's
I would
all
have
right.
waited in the hallway.
I think I said for the record, I thought I'd surprised everybody, so.
Yeah, and if, had I known, I would have waited in the hallway. I just didn't realize. there was
Okay.
All right.
I think because my license was.
You got our options.
Well,
Right.
Provide it to the licensing board.
What about the teller? I can take it back.
But it was a motion.
That's a Derek
Yeah.
question.
You get your bond back. You paid
Yeah.
your bonds.
Defense request
Okay, court.
Okay.
to
After
deny the
Harold is
motion.
Here, but the John Abbott, the one I need.
Yeah, the defendant's motion, it's not to bind them.
Your Honor,
There's got lunch at one.
Your Honor, we had like,
Meeting at one.
Your Honor, we had like 3 collateral issues. Since it's dismissed, he had a valid CPL. He would like to get something showing that so he can get this gun back. to CPL.
That I'm not sure. He's gonna have to go to the CPL purveyors, because they're gonna look at the record and indicate whether the CPL still exists or not.
Could,
My
let me call-
license,
no, call.
sorry.
And
Could he
so
get something from the court? Will you have something showing it?
there
was
should be
dismissed?
something, yeah. I'm gonna write it. We're trying to figure out how to do this. I think it's based on your request to deny the bind over that I signed a motion to dismiss.
If that's the case, then I'm officially requesting that, Your Honor.
Yeah,
We can't, we're off the record.
yeah,
Well, not officially.
right.
requesting it.
Or Vincent Alvarado? All right. This is the time set for a preliminary examination today, and it's my understanding it was meant to go today. There are witnesses that are either here or on call. Ms. Rolfe, what is your understanding is how we're proceeding?
Your Honor, my understanding is that Mr. Abbott will be asking the court to adjourn this matter due to defendant's wish to retain counsel. Is the people's position. We are ready to proceed today. We currently have 3 witnesses just actually right outside the door, ready to testify. This case has been adjourned a few times, it looks like. I think either for discovery or for defense to have adequate time to review said discovery. So I am displeased with the late notice, not faulting Mr. Abbott, but of a possible new retained counsel. We are ready to go today. This has been adjourned a couple of times. I don't know if this is a delay tactic on the part of the defendant, but I certainly will just indicate for the record that I am ready to proceed.
Thank you. Mr. Abbott?
Thank you, Your Honor. My client advised me that they've consulted with Kuntz Law Firm. I did contact Kuntz and they confirmed that there's been conversations. And it's their intention, and they understand that it is the defendant's intention to retain them. And they asked me to ask for an adjournment. And I guess under the circumstance, Your Honor, I myself also asked for an adjournment because I'd rather not start today and if we did start today, I'd have to ask the court to make the witnesses available again. So if Mr. Kuntz wants to cross-examine them further, he can. So I asked the court for an adjournment and I apologize to the witness.
All right. Well, I mean, I'm going to take very seriously the fact that the defendant gets to pick and choose what counsel, and if they're able to afford counsel and they want Mr. Kuntz, but we are on the 1/2/3 adjournment now. Okay. So make sure Mr. Kuntz knows that, because if he comes in here and he's asking for another adjournment, that's probably not going to sit well with the court. Okay. I'm just telling you now, we have witnesses here. We're ready to go. It is a complicated case, but it's not so complicated that it's something that somebody couldn't get up to speed on pretty quickly. With that understanding, though, I do believe that Mr. Kuntz you should have the lawyer that you choose to. And so I'm going to grant the motion to adjourn. We'll get a new motion date. We're going to expect this to go, but I'll wait to hear from the lawyers on that. But we'll set it at a time that gives it a little bit of safety in regards to testimony. So this would be the 1/2/3 adjournment date for new prelim. And then I'll let you decide where it should go, Wendy.
March 17th at 9:30.
So right now we have March 17th at 9:30. You will get a notice of that date. Make sure Mr. Kuntz gets that notice, okay? Because that's the March 17th date is the date he has to be concerned about getting on board. And it's going to be hard to adjourn any matters for our purposes. So when he gets it, he knows he's got to kind of hit the ground running. Okay. All right. Anything else from the people on docket 23-00059, Ms. Rolfe?
No, Your Honor.
Anything, Mr. Abbott?
Nothing further.
All right. That's all for the record. March 17th at 9:30. Make sure Mr. Kuntz knows that. All right. All right. Thank you.
Wear a green tie, St. Patrick's Day.
Yeah.
Appreciate it. Thank you.
All right, Mr. Abbott, you're all set.
I'm all set.
Yeah. That was fast.
I'm glad we didn't start today, even if